Let's talk about how we handle our prenups, postnups, partition agreements. They're basically all partition agreements, and sometimes we do them before people get married, and sometimes we do them after people get married. You can do them either time with equal effect. The only reason sometimes people want to do them before they get married is perhaps they would choose not to get married if they were not successful in entering into it. And I guess you could get divorced if that was the case and you tried to do it after getting married. But in any case, you can do it either time. And we have a nice template here to help people in your office, including you, to work on your partition agreements. I would strongly recommend that people consider the collaborative approach for prenups and postnups. Because if you think about it, of all the things we do in family law, this is the one area where we're really trying to stay amicable. They're getting married after all, or they're trying to stay married. They're not divorcing. And we really want to be cautious that we don't harm their relationship as we help them to negotiate their prenup or their postnup. So I think collaborative is a real natural for this. So I think that's something that you should consider and that your clients should consider. If you're doing it collaborative or not, I still think it's a very good idea to meet in person with both parties and both lawyers so that you can hear from the parties directly what are their goals. Because I think sometimes people think a prenup is a set in stone document, and it's not at all. There's many different things that a prenup or a postnup can do. It can identify separate property that exists, clearly identify it. It could say that that separate property, that not only is it going to remain separate, which would be the law anyway, of course, but that any income off that separate property will become separate, will be separate property. So it could have that change, and that may be their primary and only goal. Or they could have a broader goal that they're not going to have a community estate while they're married, that everyone's earnings are going to be separate. And if they do that, they might want to have other provisions. Maybe one party, if one party's the main earner, maybe they're going to put money aside every month for the other one's retirement and just go from separate to separate community. Maybe they want to have details about what would happen at divorce at various stages of their marriage. So I had a case once, for example, where they felt very differently if they got divorced 2 years after they got married than if they got divorced 30 years after they got married. You could see that, right? Is if it's 2 years, kind of what have we invested together in this project? And if it's 30 years, we've invested a lot together in this project. Especially if the goal of the prenup is that we're really not going to have a community estate. So they haven't had the advantage of the 30 years building the estate together because there isn't a community estate. So we may need to have very clear definitions of what monies would go to the non-earner at those various stages. So for example, in that case, the husband was the larger earner. The wife was actually a surgeon, so she wasn't any schmuck either, but they had agreed that they were going to have children and she was going to give up her career for a time. Well, if then he left her for the blonde, bombshell at the office or something, she wanted some protections. So at certain mile markers, there was going to be, so many millions or whatever their dollars were that were going to go from him to her if they divorced. And one thing to consider, some people want to have a fault provision. I do not recommend it. But the reason I don't recommend it is, can you imagine trying to prove that? So if there's a fault provision that he or she, gets treated differently if the other person's at fault, then what? How are we going to prove they're at fault? It would just be a nightmare. And I think one of the main purposes of a partition agreement is to avoid the nightmare litigation. So if you're really just creating it by having a fault provision, I don't think we're doing them much of a service. And the truth is that usually when a marriage fails, everyone's at fault to some degree. So how do we measure that anyway? It's just too subjective. So it's better to have very clear as possible, guidelines about what happens at divorce and what happens at death in our partition agreements. So we have here the challenge, seeing all the possible results and effects, right? So we talk a little bit here when you're negotiating about, we don't have the crystal ball. And that's the hard thing about partition agreements, is we can't think of every scenario that might happen. And so your client's having to make some hard decisions about the future when they don't know what the future holds. So trying to keep it as simple as possible is wise, and helping them to think through kind of the worst case scenarios. Okay, so let's say the worst case scenario, where would you be, is important. One thing to be cautious of is sometimes there will be provisions where in a prenup it will say that the other party does not have a right to temporary support. And I think that's a big mistake, because the other person could kind of hold them hostage because they don't have any temporary support between the date of filing for divorce and the divorce being final. So it doesn't do your client any good if they get a big award at divorce if between the filing and the divorce they have no access to money. So you want to think about that, is watch out for that provision. It's a common provision. You don't want them to be, it puts them in a very poor negotiating position at divorce, because there's only so fast they can make the divorce go. So there needs to be some protection for them at each stage, right? So married happily, filed for divorce, but not divorced yet, that's an important stage, and divorced. Okay, so the drafting of the partition agreement. We've loaded some examples in the template to help you. And then again, simplicity is king, is what it says, which I've already talked about. And avoid triggers or stipulations that are fact-driven. So that's kind of what we talked about before. If they have to go prove a fact, they're back into litigation, and they're entering into this agreement now to avoid litigation typically, and to be clear about their rights going in. You're required when you do when you're doing a partition agreement to fully disclose assets and debts, and if you don't, you risk that it's not going to be enforceable. So it's important, and you should be motivating your client. If they're the big money person, they need to fully reveal, because they're the one probably that wants this and they want it to be enforceable. So they need to provide documents and proof and schedules and everything of all their assets and debts, because somebody cannot negotiate and enter into an agreement if they don't know what they're giving up, essentially. So that's important, and people don't like to do that. Clients do not like to do this. But you have to tell them that they're risking the enforceability of it if they don't. And those are the things to consider. And you can add to this as you are working on your partition agreements, and you can put samples in here of ones you particularly like, but we have a sample to get you started, and this is our partition agreement template.